Hey guys, what's up? So many of you were asking about the Collegium system and a video to be made on that. So I have made this video. Please watch it and understand everything which you need to know about the Collegium system. So the principle of separation of power and its corollary, that is checks and balances, it is considered critical to protecting the system of parliamentary democracy, supremacy of constitution, etc. So in theory, what happens is legislature controls the finance of executive, the executive appoints the judges, and the judiciary interprets the constitution and laws and determines whether the legislature and executive are acting within their defined domain of power or not. So this was by Montesquieu. He was a French political philosopher. So he gave the theory of separation of powers and the theories of checks and balances. Now, when we talk about constitutional provisions regarding the appointment of judges, so the judges of the Supreme Court and High Court, they are appointed by the Article 124 2 and 217 respectively. Okay? Article 124 2 says that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts in the state as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. So it means they will be appointed, every judge of the Supreme Court will be appointed by the President by consultation with the judges of the Supreme Court and High Court, okay, in the states, and he will be there till 65 years of age, provided that in the case of appointment of a judge other than the Chief Justice, the Chief Justice of India will always be consulted. Simple hai? Article 217 reads, and I'll quote, every judge of a high court shall be appointed again by president. Okay, तो ये याद रख लेना, president appoints all the judges of the Supreme Court and all the judges of the High Court under his hand and seal, okay, after consultation with the Chief Justice of India. Now here comes the interesting part, governor of the state, and in the case of appointment of a judge other than the Chief Justice of the High Court. So he has to consult Chief Justice of the High Court, Chief Justice of India, and Governor of that state. Is it clear? So now this is important concept, that consultation versus concurrence. So now let us see how it evolves. So how did the Collegium system evolve when the constitution is silent on it? So let us see. So first judge's case was between S.P. Gupta versus Union of India 1981. So consultation was not concurrence. So Collegium system has its genesis in a series of judgments which are called as judges cases, and over the course of these three cases the court evolved the principle of judicial independence to mean that no other branch of the state, including the legislature and the executive, would have any say in the appointment of judges. Okay. The court then created the Collegium system, which has been in use since the judgment in the second judge's case. First judge's case, it declared that the primacy of the Chief Justice India's recommendation to the President can be refused for cogent reasons. So that was the there. So Supreme Court bench held that the term consultation, which is used in Article 124 and 217 was not concurrence. What does it mean? It means that although the President will consult these functionaries, his decision was not bound to be in concurrence with all of them in any manner. Okay. The judgment tilted the balance of power in appointments of judges of high courts in favor of the executive, who is the biggest executive in the country, President. And this situation prevailed for the next 12 years till 1993. Okay. Now after 12 years you have Supreme Court Advocates on Record Association versus Union of India case. This is the second judge's case. Okay. It says that it was judgment given by a bench of 9 judges overruled the decision in S.P. Gupta, and it devised a specific procedure called as Collegium system for the appointment and transfer of judges in the higher judiciary. Supreme Court in its judgment highlighted that top court must act in line with protecting the integrity and guarding the independence of the judiciary. And Supreme Court said that the term consultation would not diminish the primacy of the role of Chief Justice of India in judicial appointments. Okay, so it is trying to say that Chief Justice of India is at the primary level. Now let us move on to the third judge's case. Now third judge's case of 1998 is not a case per se, but an opinion which was delivered by Supreme Court of India responding to a question of law regarding the Collegium system, which was raised by the then President of India K.R. Narayanan in July 1998, which was under his constitutional powers. So what happened in 1998 was that President K.R. Narayanan issued a presidential reference to the Supreme Court over the meaning of term consultation. which can be done under Article 143 of the Constitution. This is called as advisory jurisdiction. So under Article 143 of the Constitution, Supreme Court has advisory jurisdiction. I'll tell you the exact question. The question was whether consultation required consultation with a number of judges in forming the Chief Justice of India's opinion, or whether the sole opinion of Chief Justice of India could by itself constitute a consultation. So Supreme Court response was it laid down 9 guidelines. So this is important for the functioning of the collegium for appointments and transfers, and this has come to be the present form of collegium, and it is going on till date. Now, when we talk about collegium system, the key here is the word consultation, which has been interpreted and affected by Supreme Court as concurrence, which means that they have to agree, otherwise the appointment will not be there. Okay, so they have done it on the grounds of protecting independence of the judiciary and judicial review, which we will see soon, and this interpretation lies at the heart of the debate on collegium system, all the associated problems and the systems being proposed to reform it. Okay, so collegium system basically is a system of appointment and transfer of judges that has evolved through judgments of the Supreme Court itself. It is not by an act of parliament or by a provision of constitution. Now let us see the composition of collegium. Supreme Court collegium is headed by the Chief Justice of India, and it comprises 4 other senior most judges of the court. In case of High Court, it comprises of Chief Justice of High Court and 4 other senior most judges of the court. And judges of the higher judiciary are appointed only, again I will use the word only, through the collegium system, and the government has a role only after names have been decided by the collegium. So basically the only way they can be selected is through the judges. Now let us see the role of government. So government role is very limited. So what they can do is they can get an inquiry conducted by Intelligence Bureau. Okay, now if a lawyer is to be elevated as a judge in High Court or the Supreme Court, that's max they can do. It can also raise objections, seek clarification regarding the collegium choices. But if the collegium repeats the same name again and again and again, okay, reiterates means repeating, the government is bound under constitution bench judgments to appoint them as judges. Okay, so government has very limited power. High Court names recommended for appointment by High Court Collegium reaches the government only after approval by the Chief Justice of India and Supreme Court Collegium. So this is an important point. So High Court judges can only be approved by government after they are approved by Supreme Court Collegium and Chief Justice of India. Now what are the problems or issues with collegium system? So experts says that system is non-transparent, and since it does not involve any official mechanism or secretariat and nobody knows how the selection happens, it is a closed door affair with no prescribed norms regarding eligibility criteria or even the selection procedure itself. And the most important criticism is there is no public knowledge of how and when a collegium meets, how it takes its decisions, and even lawyers are usually kept in the dark on whether their names have been considered for elevation as a judge. So there are 4 criticisms of this. Again I'll repeat: system is non-transparent, it is seen as a closed door affair, there is no public knowledge of when the collegium meets, and lawyers themselves do not know whether they are discussed as judges or not. Now addressing the issue, Justice M.N. Venkat Chalaiya Commission, it was appointed by the BJP government from 1998 to 2003, and to see whether there was need to change the collegium system. So this commission itself, which is headed by a justice, they favored the change and they prescribed NJAC. What is NJAC? Everybody should know NJAC. Okay, it consisted of the Chief Justice of India and 2 senior most judges, the law minister and an appointed person from the public, to be chosen by the president in consultation with CJI. Now when it comes to formation of NJAC, the 5-judge constitution bench declared it as unconstitutional. Okay, cool. So the constitutional amendment that sought to create NJAC, 5-judge constitutional bench declared it as unconstitutional. Then you have new memoranda of procedure of 2015. So in 2015 ruling in the end had also paved the way for a new memorandum of procedure to guide future appointments so that concerns regarding lack of eligibility criteria and transparency would be redressed, and the bench had asked the government to draw a new MOP after consultation with CJI. So basically that was 99th Amendment, and NJAC Act was quashed by the Supreme Court. Okay, so 99th Constitutional Amendment Act was quashed by the Supreme Court. So when we talk about NJAC, so government had established, the full form is National Judicial Appointment Commission by way of 99th Constitutional Amendment, and it was envisaged as an independent commission to appoint and transfer judges of High Court and appoint judges of Supreme Court of India. It composed of 3 senior judges, 2 eminent outsiders, and the law ministers. And the constitutional amendment was passed by parliament and it was ratified by 20 states. And the motive behind creation of National Judicial Appointment Commission, it was to bring reforms in appointment process of Indian higher judiciary. So now let us see quashing of NJAC by Supreme Court. So the court by a 4-1 majority struck down the 99th constitutional amendment as unconstitutional, and the new provisions in constitutions are insufficient to preserve the primacy of the judiciary in the matter of selection and appointment of judges. So this was the judgment. It was held that the amendment impinged upon the principles of independence of the judiciary as well as in the separation of powers, and consult Chief Justice of India and form memorandum of appointments of judges of higher judiciary. So that was the entire judgment. And maintaining of supremacy of judiciary was the reason was government is major litigant. Since the government is a major litigant, give it an edge in appointments would amount to fixing the courts. And independence of judiciary is regarded as a basic structure of constitution, and NJAC was termed as violating the independence of judiciary, thus it was violating the basic structure of constitution. And it was also to enable separation of powers between executive and judiciary as directed by Constitution of India. Now let us see this key highlights of memorandum of procedure. So first is merit and integrity should be the prime criteria for appointment of judges to the higher judiciary. Okay. Then you have yardstick for promotion as a Chief Justice of High Court. So all the evaluation of judgments which are delivered by a High Court judge in the last 5 years and the initiatives undertaken for improvement of judicial administration. Third was it seeks to introduce performance appraisal, okay, as a standard for appointing Chief Justice of High Courts and Supreme Courts. Then fourth was a permanent secretariat was to be set up in Supreme Court for maintaining records of High Court judges, scheduling meetings of the Collegium, receiving recommendations as well as complaints and matters related to appointments. And fifth is Union Law Minister should seek the recommendation of the incumbent Chief Justice of India for appointment of his successor at least 1 month prior to his retirement. So the recommendation of that will be taken. So lastly, let's see the United Kingdom system of judicial appointments. So the appointments to the higher judiciary in UK were until recently made on the recommendation of Lord Chancellor in the consultation with Lord Chief Justice. And the principal challenge for the Chancellor was to make sure that the appointments did not carry the color of the politics as he himself. So after the Constitutional Reform Act of 2005, everything changed. So the appointments are governed by it. And as per the 2005 Act, the Judicial Appointments Commission itself consists of a lay chairman. Lay means who has never held judicial officer, they have never practiced law, and it will contain 14 other members, which includes 5 judges. So one will be each from Court of Appeal and High Court, one from either Court of Appeal or High Court, one circuit judge and one district judge, 2 practicing lawyers, 5 lay members, 1 legal tribunal member and 1 lay magistrate. So the critical feature here is that the representation of members will be from diverse fields, and especially the lay members will be involved more, so that will ensure transparency and accountability in the system. So the conclusion is such a similar system involving widespread representation of people from all the fields may be created in India also to protect against like domination of executive and destruction of independence of judiciary, and making the proceedings of the commission public after a time lag, and ensuring close scrutiny of the arguments in favor and against appointment of a judge seems to be the way forward. So I hope you have enjoyed this. Thank you for watching this. Have an awesome day.